Hi, Glenda back from Top Notch Legal, and today I'm going to conclude the discussion I've been having over the past few weeks about how power has been given to small business to negotiate with big businesses on their contracts. It all comes under this new regime called the Unfair Business Contracts Regime. Now, today's topic is going to be about liability. So what's happened in the past is that standard contracts of large businesses often included provisions whereby the small business was required to be exposed to a substantial liability whilst the big business had almost none at all. And these types of clauses have now been declared unfair and void. And the first case that involved these types of clauses concerned J.J. Richards, which was a waste management company. And they had a clause in their contract which required the small business owner to indemnify them if any claims were made against them by a third party. And basically they didn't have to show that the small business customer had caused any of the losses. But J.J. Richards, on the other hand, would not be similarly liable. So the ACCC treated this as a test case. It was the very first one under the new unfair contracts regime. And it was found that this clause was unfair, it was unbalanced, and it was void. 18 clauses in J.J. Richards' standard contracts were declared unfair and void, and they were directed to rewrite their contracts. As a result, many large businesses around Australia, including banks, rewrote their clauses. Now, that's not to say that all these big contracts from big businesses have been written. They have not. And many of them still try to push it across to the small business owners. I see them come across my desk, so I know what I'm saying. So I hope that this discussion has helped and encouraged you to realise it is worthwhile negotiating with big business, that the law is now on your side. That's it today, Glenda from Top Notch Legal.